name.
Okay.
All right?
Yes, ma'am.
So then tell me what are the disadvantages? I'll start with you.
Disadvantages.
Yes.
Um,
The disadvantages of a sole proprietorship. Let's talk about the main one. What's the main one?
Shared profit.
No.
unlimited
I mean, not shared
Un-
profit.
Unlimited liabilities.
unlimited.
Yeah. What's next?
Limited resources.
Limited skills.
And capital. Limited capital.
Limited resources.
Limited capital.
But all that go into resources because he only has so much.
Company dies when you die.
Yes.
Dies when he dies.
Anything else? That's roughly it, right? I'm doing it separately because of the newcomers. But the question would normally be for you to compare the three. Got that? What's the advantages of a partnership?
Limited liability.
Joint liability.
You have joint liability. What's the other one?
Shared resources.
Shared resources. Anything else for partnership?
A possible increase in capital.
Are you putting down
Yeah,
some
that'll
other
be there.
resources? So we can share skills then?
Yeah.
An increase in capital.
Do we have shared resources?
Okay.
Anything else?
The company doesn't die.
Partnership?
The partnership.
It depends.
Depends on the
Depends on the agreement. Anything else?
No capital.
Yeah. We know they don't have any capital, and everything is based on the partnership agreement. So I put the dis in the front. What are the disadvantages of a partnership?
Debt,
Mm-hmm. Yeah. Uh-huh.
Disagreements.
Yes.
Joint assets. What is the second one?
Where?
Sorry?
Disagreements.
Okay.
Anything else?
That's a disadvantage.
Unlimited liability.
Oh,
Yeah. Unlimited. no volunteer. How would you answer that? Who volunteer in this town? Yes, using decided cases.
Oh,
So the first thing to do is what? If you had to write this, what's the first thing you would do?
Determine what case you need to use.
What cases you need to use. So let's see, what cases you gonna use? There you go. That's the first one.
Yeah.
What else you gonna use? You could use that. But you only have 3 there. What's in effect?
in a different, oh, but that's the definition I thought we were talking about.
What is what?
What it means to be a legal entity,
What it means?
types of companies?
What? No, doesn't answer that, no.
No? Oh,
When you say a company is a legal entity, this calls for you to discuss
oh,
this case
oh, okay,
in detail.
okay.
The facts
Uh-huh.
and why the courts decided that Solomon was separate from his company. So when you answer this, you seek to confirm why that principle exists today. Why a company is a separate legal entity. And that case decided that. That's why you must know the case of Solomon versus Solomon. Anyone read the case of, what is it called? What is this? Macrono? You remember that one, Macrono? You got that? Okay, read that one.
Okay. Macarona versus Northern Assurance Company Limited appeared before the House of Lords concerning the principle of lifting the corporate veil. Unusually, the request to do so was in the case made by the corporation's owners. Mr. Macarona owned Killymoon Estates in County Tyrone, Northern Ireland. He sold the timber there to Irish Canadian Sawmills Limited for £42, fully paid up at $1 per pound per share, making him the whole owner with nominees. Mr. Macara, was also an unsecured creditor for £1,900, for £19,000, He got insurance policies, but in his own name, not the company's, with Northern Assurance covering for fire. 2 weeks later, there was a fire. Northern Assurance refused to pay up because the timber was owned by the company, and that because the company was a separate legal entity, it did not need to pay Mr. Makara any money. The House of Lords held that the insurers were not liable in the contract, since the timber that perished in the fire did not belong to Mr. Makara, who held the insurance policy. Lord Buckmasters gave the first judgment, holding in favor of the insurance company. Lord Atkinson concurred. Lord Sumner concurred and said the following: My lords, the appeal relates to an insurance on goods against loss by fire. It is clear that the appellant had no insurable interest in the timber described. It was not his. It belonged to the Irish-Canadian sawmills of Skipperdean. He had no lien or security over it, and though it lay on his hand by permission, he had no responsibility to its owner for safety, nor was it there under any contract that enabled him to hold it for his debt. He owned almost all of the shares in the company, and the company owed him a great deal of money, but neither as creditor nor as shareholder could he insure the company's assets. The debt was not exposed to the fire, nor were the shares, and the fact that he was virtually the company's only creditor, while the timber was its only asset, seems to me to make no difference.
Right, so to answer this question, first, you have to explain what is a legal entity. You have to explain the case of Solomon versus Solomon and why a company is a separate legal entity. Then you have to explain when the courts will pierce the corporate veil. So just the very first question we did, which was just on piercing the veil. This one requires you to do the Solomon principle and when you can pierce the veil. Because piercing the veil challenges this separate legal entity. That's when you pierce it, when you challenge it, when you say it is not what it appears to be. And the more of these cases you read, then as you can see how you've read yours, some of the stories, the minute I said it, you were able to get the case.
He said, you just explain, what is the legal entity? Explain the case of Solomon v. Solomon. And what's the third one?
Then you're going to actually talk about when you can pierce the
No, you
corporate
said
veil.
that was the fourth one, you said the corporate veil. You said something else first.
What is the legal entity? Explain the case of Solomon versus Solomon and why the court decided
Oh,
that he and the company were two separate individuals. And then you give piercing the corporate veil, which is the exception to the policy.
Are we just listening now?
No, you have, this is
Describe it?
actually,
Okay.
you actually described them. So we good? Yeah? Tarika, you good?
Yes, that last one was McCall versus Northern Assurance.
Yes, Company Limited. 1925.
Okay.
tortfeasor.
And of like.
In a civil suit. Discuss when a director may become a joint tortfeasor in a civil suit. How would you approach that?
I would list the statute, I think, that identifies this. Is it the statute or is it the? I think, honest, isn't this question dealing with when there's fraud and other things, they breach their fiduciary duty in order to become a tortfeasor? I think in the statute defines
The duties.
their duties,
Right.
the overall duties, I think.
Of a director?
Mm-hmm.
So I would list the statute first, I think, is what I would, that's,
Okay.
I think that's what I
So
would
the first
start.
thing is a director's duty of care. IBC is 50.
Kristen, can you read the question?
Where?
Discuss when.
That isn't a.
Discuss when a director may become
When you become
a joint tortfeasor in a civil suit.
Oh, so it's-
Yeah. So one, a director's duty, statutory duty. I know it's section 79 of the Companies Act, and in the IBC Act it's 55. I think in the IBC Act it's 55. Yes, 55. What you gonna talk about next?
Shouldn't it be 81 for the Companies Act?
Duty of care? We got 81. In my own, I have 84. In another class, I thought they took it straight on from online, and it was 79 from the laws of the Bahamas.
This online.
They got theirs online too. Mine was online too. Each one has a different one. And theirs are all of these, same thing. But they have a different number. Theirs was 79.
But then they say duty of care for the Companies Act.
Yeah. And I can show you mine, and mine is 84. So I don't know which one is the right one.
The ones we have the duties indicated as.
Once you have the
the
number here, yeah, don't matter. I don't worry with the number.
79 I have.
That's what I have. No, I don't have, you have 79. She has, what number you have?
81.
81, and I have 84.
No, but they have duty, they have, for 79, they have duty to manage company.
Yeah,
And 81 is duty of care.
Right.
That's right.
yeah, but her number's a different number. Which one you have?
I have duty to manage company for 79.
Okay.
And duty of care, 81.
81, okay.
But somebody purchased this for me when they,
But I think it's where you get it from.
yeah, and they, when
With
they
sauce?
did, they consolidated the amendments.
Okay, so you have 81. I still say mine is 84. But I printed mine a year ago. That's a lot of people.
Yeah, so in this case, for terms of approaching the question, we would indicate the duties of the
Statutory
director,
duty of
statutory
care.
duties outlining that. And then we'll indicate the case that supports it.
No, then you have to talk about when can he become a joint tortfeasor?
Oh.
When? When can it occur? When? How does that happen?
Oh, so we'll be able to provide all of this.
Well, when he breaches that stuff, goes in the registration.
Yes, when he breaches it, yes. Mm-hmm. I gave you two cases. MCA and Standard Chartered Bank.
What is that set out in the?
M&A. That was a good review of chapter 1. Yes?
This way of showing us how to answer these questions.
Okay, so let's begin unit 2. Types of companies. First type. What's a private company? What's a private company? These are not shareholders. Private company. Oh, I see plenty highlights here.
You want to put out you want the public financial base for private company?
Yes,
But you don't,
if
but
you're
you
regulated.
don't have public shares. You don't have public shares.
You don't have public shares.
That's right.
You have public share offering. So what's the second category? Public company. And that's the one where the shares are public. And then you can have a statutory company. So a private company can be limited by shares or by guarantee. What does that mean? Shares or by guarantee? I heard silence. It's not golden. A private company can be limited by shares and by guarantee, or just shares or just guarantee. What does that mean? When we say a company is limited by shares, what does that mean?
Mark something about shares you have.
your liability is limited.
Limited to the amount, yes.
Right.
Limited to-
Okay? And when we say by guarantee, what does that mean?
They got no shares?
No, there are no shares, but what's the guarantee?
Constitution defines the guarantee.
What?
The Menonite will define, how liable you are.
Mm-hmm.
The Constitution would state the amount at which they would hold, the liquidation, they go on.
Right, the winding up. Each member guarantees an amount. That they will contribute at winding up. So one is before and one is after.
So what happens
If it's both.
if,
If it's both,
no,
no, someone asked if it's
if I'm,
both.
oh,
If it's both,
mhm.
then it's called a hybrid company.
What happens if one of the members cannot, deliver on his guarantee, the amount at winding up?
Because he's broke.
Uh-huh.
So, he gave a guarantee. And normally when you give a guarantee like this, upon giving this guarantee, you would have the bank issue a guarantee letter.
Okay.
And so, let's say you guarantee 10,000, and you have 10,000 on fixed. When the bank issues that guarantee, that money is on hold.
Yeah.
You have no access to it.
So the guarantee is always issued by the bank?
It depends on what the assets are. And notice, you would never have a guarantee under a public company. Very rare. Why wouldn't you have it? Why wouldn't you have a guarantee under a public company?
Because,
Because they're
the
the
shares.
shares. To be a public company, what you're offering? Shares.
Shares.
So you can't have a guarantee here. So which type of companies would normally have guarantee only? There's a lot of them in the Bahamas. Unregistered.
NGOs?
Or NPO, or you call them NGO, non-profit organizations, charities.
Non-profit, and what is the other?
Non-governmental organizations. So what's a public company?
Company issue shares.
Mm-hmm. And went to the
Public.
public. Now, don't forget now, it's owned by the shareholders, and they have more disclosure. And when I say disclosure, it means they have more filings, more requirements, more publications, and they have more rules to follow. If I say the regulation for public companies is stricter than the regulation for private companies due to its ability to offer securities to the public and in protection of the public interest regarding the sale and purchase of such companies. So, which companies do we have in the Bahamas which are public? Cable Bahamas is one.
I think the brewery.
Commonwealth Brewery. Who else? Next, see. Commonwealth Bank. Uh-huh. The Port. Who else? I don't know if the bridge trade. That bridge was a mortgage bond.
Yeah, I think they borrowed.
Yeah. Their shares? I don't know if they trade. I don't know if they trade. They trade? On the stock exchange.
No, I don't know, I'm sure.
Is Fidelity on the board? On the stock exchange?
Yeah, I thought they were.
And then soon to be would be IL.
Who's I
That's right.
Island.
And the soap opera.
Yeah, they want to do an IPO.
An IPO.
That's a good buy.
Huh?
That's what they get. In fact, they were rules. Try to government.
Can you think they might make them as much money as you think they are? And they won't share.
You mean within the confines of their license?
No, but their license, the taxes is what, 50% the government supports, huh? 50%
Yeah,
they
because
back
it's
the
a-
government.
it's
Before
a-
it was like 17, I think.
Yeah, but remember now, the operations of that company is a, what you call it, hobby?
Yeah,
It's like a hobby. So that's why it's heavily taxed. It's a leisure, it's a leisurely thing, not a
The
job.
casinos is the same thing,
Yeah.
but they don't tax the casinos as heavy as they tax the local ones. And the casinos, the more money
That
they
was
make,
their
the less
argument.
taxes they pay.
But that's the advantage of them coming in and employing the people, that's a set off.
Yeah, but the government just forgave what, before Bahama went, they forgave the casino at Cable Beach. That was there, the millions and millions they owed the government. They also forgave the casino in Freeport. So, to me, it is not an advantage for employment, because they still writing it off anyway, but then you can tax the local man, because he's trying to make some money out of the wazoo.
I think if you make it an
Yeah, but
IPO,
I
it may
think
be
too-
better, this is one man.
But
I
that
think
was
too,
their way of
the
saying they
thing-
can give
I
back.
think too, because the
In order
Bahamians
to
Yeah,
cannot,
spread, yeah.
Bahamians cannot pay.
Yeah.
Bahamians cannot gamble. This is my thinking. The Bahamians cannot gamble in the casino, whereas the Bahamians can go to Island Luck. And when Bahamians can go to Island Luck, you have social ills.
Yeah, but you see,
So you need to go,
But
still have
when
some
you
money
look-
for social services.
but when you
Mhm.
look at Island Leftovers, they give back to the community all the time, and I think right now they're giving more back than some of the churches do.
Yeah,
Even though
but
you
the-
say it's a
But
social
the,
ill.
but the church has
This
to
is
do with your soul.
a social ill, though.
I don't
Churches
think the
give you
government looking at that. I
guidance.
think they're looking at the fact that
But
they
my
make-
thing
they
is,
making a lot
why
of money.
make
They
it
make a
easy
lot
for
of
the
money,
people
now
to
whether it's
get
legitimate or
shares?
not, you'll find out when you become a shareholder,
Why
then
do
it's
you,
time to get your dividends, based on the amount of money that they're making.
I think it's legitimate because they have a license to do so. Now, whether or not every service they provide is underneath that license, that's the question.
That's another question, for
But
the
they
amount of
have
money
a
that they make.
license to do so, but the license, I think they're trying to offer, to establish the IPO, so it will deter the government from taxing them so heavily, because if they know that Bahamian people are also shareholders, it will create a public disturbance, if because I'm a Bahamian and
That
I'm a
means I'll be getting
shareholder.
less dividends.
Yeah.
Yeah.
Mhm.
See?
Because you'll have more stake in the company.
Yeah, that's their way of giving back, I guess, allowing the Bahamians to have a stake.
Well, that's
For
one
those-
way.
For those who
That's
interested.
okay, so that's from that end for the company, and at the same time, they can actually raise more capital,
That's another thing they make.
right?
They could use it for
Yeah.
investment.
But you think that taking capital?
No, they don't, but it is a way, there's a way to do it.
To
Because
raise
right now,
money.
you don't really know if the money that they use to generate is not coming from another operation.
True.
You see what I mean? So when you do an IPO, it's public. And everything must fall in line with the license that you were given. And you can't go outside of it. Right now, it's private. So if you do an IPO, then it's just pure gaming. Pure. And your returns will be on that.
Yeah, because the money that they raise, say they raise about almost 10 million or whatever in one offering.
Mhm.
They could use that to make more money in another industry.
Another industry.
So that it's almost like they're cleaning their money in a sense. I
Yeah.
guess.
Well, that's
Now,
why
now you
they
only
buy
use
it.
the word, you only use
Not
cleaning
cleaning, but
if it's
it's almost
illegitimate.
like they're reinvesting it.
Right.
Reinvesting
Because
it to,
remember
to
now,
go into another industry.
each entity is a separate person.
Uh-huh.
So he has his holding company at the top. Then he will have here, here, and here. Another company will be for gaming. Another company here for property. Another company here for whatever else he does, because I hear it's plenty.
Yeah, you have a construction company.
'Cause we have-
Does he bill his own?
Money transmission.
He have a money transmission business too?
I'm just saying.
Oh, yeah, okay. So he has all of these companies.
Then you have the what, TV station?
And then you get the
Radio,
TV station, there you go.
TV and the radio.
So say broadcasting.
But then they
And I
say
think he
you
made,
said
I think he
could
made,
you could
started
send
trying
money
to
to
start
the
a
family
school.
island.
Yeah,
Yeah, so
they,
those money transmission.
they stopped that
After school
now
for
though.
children?
I know.
Central
Like
Bank
a,
kept them on
a
that.
school,
Yeah,
a
yeah.
non-profit organization, he was trying to start something like that, I believe, like, that's
But I
the
think
law.
that came under, no, that ended up coming under somebody else. That
Oh,
ended up coming under someone else. They thought it was his, but
Oh.
it ended up being someone else.
so he can put this as an IPO. And then remember now, each one of these can borrow from another one. And each one of these, and he probably most likely has what we call an administrative company. And this company can offer its services to these and then pay them, and it comes here. And then he can take the money that he makes from here, 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 and here, all of his dividends, and then he could just put it in his trust. So he's very wealthy.
I have a question. Is it true, I'm not sure, I don't know if I heard this or what, that some of the commercial banks don't allow them to bank with them?
Yeah, for due diligence purposes.
Yeah. That's a different issue. Remember,
That's why they
this,
doing the
this
IPO.
business here, gaming,
Mhm.
is high risk. No matter where it is in the world, it's high risk. Why? Because the borders are open. Anybody can come in and play. So even though to be a customer, you have to take in your IDs. No one checks to see where your little $50, $10, and $100 coming from. And that's why it's just open. Because I could turn around and give 500 people $100. And all of them deposit it. And money laundering is taking
You
place.
can't target fraud for that.
No, you can't, because all the money is small. So yes, an IPO. It's being talked about a lot,
He's a smart guy.
and most likely. See, nothing is better than when you establish a company with something that is new. If you wanted to open a dress store now, you won't make any money. Unless you bring in something that behemoths have never seen before and cannot fly and get it. It won't work.
Or you have to really price, have a good price.
Or have a good price. And something they haven't seen before, once they see it, or they find out where it's coming from, they don't want it anymore. But what he has gone into is something that is for leisure. It's like the movie theater. But the only thing with the movie theater is that changes with time. In other countries, people don't go and sit in the theater no more. The theater streams it to your house and bring the popcorn and the hot dog to your house. That's the first thing why we haven't changed. Second thing is nobody sits in those chairs anymore. Everywhere you go travel in a movie theater, they have big leather armchairs
With waiters,
and waiters, and they serve dinner.
fruits and everything.
Food.
It's an experience, that's
Yeah.
what you're going to
Right.
theater for.
So at the very beginning, that was the experience we wanted. But that experience is out of date.
Convenience is winning over experience.
Yeah. You see, you want to sit down, relax, someone bring you your meal, and a nice comfy chair, and you kick back. Not another jam-up chair.
We just stand on the line.
Right. You see? So if that company is still private, if it wants to survive, it must go public. But what's the difference if I go from private to public? Why would they be afraid to go from private to public? They lose control, yes. And we like control.
Yeah.
We want to make our own decisions, because when you have it public, the shareholders have something to say.
Unless you offer, what is that? Shares with them, right?
So
Does
who's
that
buying
make
it?
a difference?
Yeah, who's gonna buy it?
No, I'm asking if there's any instance where people,
If you, let's say, if you have some 5 investors who you know, who you just want the money. They're not interested in how you run the company. You just want to borrow the money. You could make them investors with no voting rights. But if you open that up to, no. But even if you have 5 investors that you wanted just to get the money, it still remains private. Public means you put it out to the world.
okay.
And you can still have it in voting and non-voting. But you will not be the only person making the decision. And then don't forget now, once you become public, then you have to follow all the rules and regulation of the regulator. So nothing is no longer secret. So that's another reason why he probably wanted to do it, to build the confidence of the gaming board. Because he'll say that the Bahamian people themselves are bought into this. If you shut this down, all these people who are expecting this dividend, what are they going to do? Because they have invested. And if you put the shares minimum of $1,000, you're talking about a lot of people putting in 1,000, or 2 people coming together putting in 1,000 and more. So it's a lot of things to think about. Now, take it from the flip side, when she spoke about, what you call it? No, what you were saying, laundering, that is another issue. Can we take the risk as a jurisdiction to put our money in a company that has a dark cloud over it as to the source of this initial funding? Because once there's a cloud on the initial, let's say the initial amount was $100 to start at, $100. But 10 of that was tainted. It doesn't matter. They say all is tainted. So even though you keep going and going and going, it's still tainted. That's the question. As a country, are you ready to go down with that? Or do you stand outside and let it go down by itself? That's the risk. The country, that's the thing. So that's a serious question when they decided to come an IPO. The regulators have to look at what are the ramifications of widening the shareholder base. How will it affect us as a country? and something, again, that all of the domestic international banks will not accept. So what are you gonna do with your shares when you get it? Because they're not gonna take it as security against the loan. What are you gonna do with it? Hold it and do what with it?
Let's live off the dividends.
Profitable.
That's the only thing you can do.
Gonna do what?
Live off the dividends.
You live off your dividends. But I'm saying if you, let's say if you invested 10 or 20,000 and you wanted to go to the bank for a loan, they're not gonna take it.
No, it's not gonna.
So it's practically like you had to wait this piece of paper. So that's what you have to think about. So you can also have a statutory company. And the statutory company is picking up now in the securities industry. Anybody know a statutory company? Well, it's one that we promote, which is the SAC.
And what is the SAC?
Segregated account. So we use this in investments. So you form a company, and then you establish it under the segregated account legislation. So if you use it in a mutual fund, so when you issue a mutual fund, you have different subscriptions. You have A, B, C, D, E. Each one of these have different investors. And so you would incorporate the fund, and then you have each one of these registered as a segregated company. Why? If something was to happen here, you don't have access to none of those assets there. Each is separate.
Is that considered class?
Yes, each class is separate. So you have to be very careful when a broker says that he wants to establish credit using this mutual fund as collateral. Because based upon the amount, these cannot offset each other. Each is separate. So how do you form a segregated account? A company which is incorporated or registered under the Companies Act or the IBC Act applies to the registrar to be registered as a SAC. So the first thing you have to do is incorporate a company. Then you have to have it registered as a SAC with the prior written consent of its primary regulator, and is engaged in one of the following businesses: investment funds, issuing securities, insurance business, a subsidiary of a bank or trust company, not licensed by the central bank, with the written consent of the central bank, or engage in any other business with the written consent of a primary regulator, who may be prescribed by the ministry responsible for companies, or if applicable, its investment funds administrator. Or it could be a limited duration company, where the company is just limited to a number of years. So, when you see it mostly with investment funds. A lot of investment funds have segregated accounts for liability purposes. So let's look at a company. The first thing for a company is, it's required by law that they must have a registered office. What's the purpose of the registered office? why does a company have to have a registered office?
Maintain their corporate records.
Yes, it's to maintain their corporate records. You know what section it is in the act?
Um,
Where it says they're required to have a registered office. If not under the Companies Act, you can find it under the IBC Act. Get mine up a different number from yours. That's what I have 17 too. Okay, 17. A company incorporated under this act shall at all times maintain a registered office in the Bahamas. The address of the registered office, if not submitted for registration with the memorandum, shall be submitted to the registration within 30 days from the date of incorporation of the company. It says that the company is required to maintain certain corporate documents, M&A, share register, minutes of meetings, and resolution. The company must have at least 2 directors and 2 shareholders. Where is that in the act? Mhm. 2 shareholders, 2 directors. No? Why does the number in there?
Is that number of directors?
No, we're talking number of directors and number of shareholders.
Number of directors? What are we talking about?
80, okay, shareholders. That at the beginning. Where's your- Oh. Found the one for directors.
Section 80.
80? Yeah, that's for the directors, not the shareholders.
Oh,
We can hear you, you know. We can hear you. Why you saying, oh Lord? He call you?
oh no, sorry, I was yawning.
Oh.
Sorry. I was yawning. I'm sorry.
Yes.
Found the requirement for 2 shareholders?
No.
No.
I'm looking.
Someone find it under the IBC Act at the same time. Number of shareholders, number of directors.
The register of members is different from the register of shareholders?
Same thing.
Oh, so that's, okay,
Yeah.
You could also look in the IBC Act.
Under the IBC Act, it's required. And how many required?
For director, IBC one,
IBC 1, shareholders?
1.
Okay. So it says the secretary or an authorized person under the provision of the articles is required to affix the seal of the company.
43 says the number of directors shall be fixed by the articles and subject to any modifications in the memorandum of articles. It doesn't say one. The articles may be amended to change the number of directors. In the IBC, it doesn't say one. It says it's fixed by the articles.
That's for the shareholders.
Number of directors in the IBC.
Where you 50,
43 is number of directors in IBC.
yeah, it says that, and then it goes down to speak to a 53, where there's a meeting of a single director or single shareholder, so the minimum is 1. Oh, yeah. So it says that the secretary of an authorized person under provision of the articles is required to affix the seal of the company to certain statutory documents. What's the seal? And why is it required? I notice in other countries, the seal is not required. So why do we need a seal? Every time someone incorporates a company, they get a seal. Why?
Distinction, they say that means that it's a company. I don't know.
Just verify that the company document,
Mm-hmm.
the legitimacy of it.
What other jurisdictions don't require a seal? They don't?
So why?
They don't know why we be asking for the seal. If they send you a sheet of paper, they will send you a resolution on a white sheet of paper, no seal, no date.
Did you need a seal for the resolution, or you need for actually?
It depends if you
No
You
seal.
don't need that?
They don't have a seal. The company doesn't have a seal
So why do we require it?
because the legislation says you must. Can you find it? Company seals are required.
26.
26 by law.
I have a question.
There is someone.
We had a scenario at work this week and I could not explain why.
So you really know that
Is the company seal required in the case of a receivership? And when would you have to use the company seal in the case of a receivership?
Why would you be making this seal? This is the liquidator using it.
The receiver, yes, the receiver is, well, it was asked that the receiver use the company seal for particular agreement. And we couldn't understand why we were asked to use a company seal for
But
receivership.
the receivership is going towards winding up,
Yes,
or, so why would you
for the
use that?
sale of
Or-
an asset.
You won't use it for sale. You use it for sale.
But legal counsel came back and said we didn't have to use the seal.
I
It
can look it
wasn't
up.
required.
I'm gonna look it up in the rules. In the new rules.
Yeah. Is he still trying to figure out what,
Is it not to validate the document if it's?
Yeah, but how come is this there in receivership?
Oh,
See, it's not a going concern company. So whether or not in his position as receivership, he carries on the powers of a director. And in some instances, he does. Under the winding up amendment. So this company is a receivership, voluntarily or involuntarily. So it's by the courts. But it's involuntary, so it's by the creditors, or it's by the creditors. they ask for the seal to ensure that the funds come back to the company?
I presume that's why they were asking for the seal.
And the receivers are auditors?
For the most part, yes.
I have to look at the rules.
And then, see, in some cases too, because you're the receiver, in some receiverships, you're only, receivers over certain assets, but not all of them. But in this particular case, this particular asset, the receivers wanted to sell, or they wanted to put this particular asset up for sale. But in order to put it up for sale, or to list it for sale under the MLS agreement, the realtor was asking that you apply a company seal. And we were concerned as to why we would have to, first of all, do we have a company seal, or do we need a company seal for receivership?
I can look at the line about, as to the powers of a receiver. Because I know he has to report to the board, to the directors, as he makes progress in what he does.
But not so much the directors, but the creditors.
Yeah, but the creditors now, because the creditors are there, but I don't know why would they ask for a seal. This is a local property firm, MSLA. I don't know why they don't want to seal. I don't know why. I can look it up for you. So section 26 says every company should have a common seal with its name engraved thereon in legible characters. If authorized by articles, a company may have for use in any country other than the Bahamas, or for use in any district or place not situated in the Bahamas an official seal. That's another thing. What is the M&A seal of the company? Does it speak to the use of the seal in the M&A? What's on in the M&A stipulate when you can use it? Yeah, because sometimes it tells you when you can use it. And may even speak to when the company is in liquidation. But that's a strange one. Okay, so the registrar has recently implemented its company's e-service, and I always say recently, because every time I ask, it's not working. It's working, not working, halfway working, quarter-way working. So, incorporate a company, the first thing you have to do is what? Check for the name. Reserve it. Then, after that, you have to decide what the name is going to be. That is just words, combination of words, symbols, if in English, foreign language. So you have to make already do symbols, scripts, characters, distinctive marks, all of that. Your section of the Companies Act. Does it speak to that? In your version of the different marks that you can have. Let me see. The different ways when you incorporate a company for its name. No? It should be in yours.
Yes.
Uh-huh.
We did 2 words, you know.
What's that?
Well,
What does it say?
It says that you have to have, it's so long.
What does it say?
It have all these things, man, restriction on names of company, that's what you mean, right?
So it says it's identical with that under which an existing company is already incorporated under the former act or under other act concerned with the incorporation of companies or which so nearly resembles such other name to be calculated to deceive or confuse except where the company in existence is in the course of being dissolved or signifies consent in such manner as the registrar approves. Continuing without express prior permission of the registrar, permission may be withheld without signing or using the word assurance, bank, building society, chamber of commerce, chartered, cooperative, exchange, imperial, insurance, municipal, royal, or word conveying a similar meaning or any other word that in the opinion of the registrar suggests or is calculated to suggest. Am I reading the right thing?
Yeah,
The patronage of patronage of the government of the Bahamas, or minister of the government of the Bahamas. A connection with the Ministry of Department of the Government of the Bahamas. A connection with any local authority or statutory board or is indecent, offensive, or in the opinion of the registrar is otherwise objectionable. Where a company is incorporated under a name that is identical with a name under which a company in existence is already incorporated or so nearly resembles the name of another company in existence which is already incorporated as to be calculated to be deceived or confused.
okay. So, go to section, reserving a name. Is that 15? Okay, so at least I have the same number. No, this company's out. Reserving a name?
A person may apply in the approved form of the registrar for the reservation of the name settled in the application act, the name of an intended company or the name of which an existing company proposes to change its name. The name of an intended company may exist of words, be a combination of words and numbers, or C, contain a dual name which shall include English and foreign names, in which case the English name need not be translated of the foreign name?
Yeah.
Okay.
So that's why when you go in the Hilton, everything is in Mandarin. No English under it.
So they do not have to put, that's what they're saying, they do not. So how are we supposed to know?
That is why they're offering you Mandarin. Continuing education.
Okay.
Yeah, see, you learn something new, right? See, now, statutory, she thinks she printed the wrong thing.
I don't have that either.
I know how, what she just read.
That probably is an amendment.
That is an amendment, 2014.
Yeah.
Because it's not in mine, I just have
Because
the
what I
amendment.
had
What
this
is
and then
the
somebody
section
to
in
the
your
attorney,
amendment?
they gave me this, I can email if you want it. They gave me this, they said this is the amended version, they
Oh, she didn't even mean that for all of us.
Consolidated,
Yeah, to say, I just have the amendment.
they consolidated everything.
Section 15 is amended.
Mm-hmm.
19th of September.
Yeah, 2014.
So when they consolidated the first,
Yeah. Christine, what I'll do, I'll email it to Gil.
Yeah, and then email it to everybody. So yours is not the right one.
I don't have that.
Yeah,
No, what
okay.
you're saying. So they did it in 2012, like,
2012 and 2012. Yeah, that's an amendment for 2014. But what she has, that's all consolidation. So that's good. So the company name is reserved initially for how many days? Let me see what you have. You went back, go back.
What section was it at?
15. Tell you right now. How many days you reserved for?
Period of 6 weeks?
That change.
Or change?
Wait,
you have the reservation of name, section 15, is that here?
I think it's 7 days, no?
See it? No,
28.
28.
28 days.
Yeah, she has it in hers, 28 days. 28 days. You see? That's the 2014 amendments.
The application.
So see, I have mine written in pen, 28 days. So she has the right one. And extensions for how many days? 14. Okay. And how many extensions can you get? Two.
Additional,
And each is for a period of
14.
14 days. So that's also in the 2014 amendment. Don't worry, there's no exam question on how many days. There's no exam question on the fees either.
14 days. Sorry, the extension is 14 days and what was after that?
14 days.
Yeah, and you have two.
And you have two, yeah, 14 days. And thereafter you may grant 2 additional extensions, which should each be for a period of 14 days. Then I'll take a volunteer. What?
You're too tiny.
Yeah. Sorry, I don't write big.
Ooh.
So y'all gonna have
You
to
have to come up.
come up to look at the answer, and then y'all could go back. I'm sorry.
If you get it writing, then I'll read it.
You said by the judiciary, right?
That's what I said. Smaller. Even smaller. What this? It's so small.
I can't remember what case I read, but he was talking about like the training with the engineer or something like that.
Okay. I just gave you a handout on some cases on this thing the video. All right, so let's start. All right, so let's look at the question and what she put on the board. You can see the board, right?
I can see the board, but I can't make out.
Okay,
You're not the only one.
so let me read what she wrote. She
Okay.
says, lifting the corporate veil by judiciary, which is the courts.
Okay.
First, she used the case of Adams versus Cape Industries. Who read that? You read it? What was it about? Why did they decide to pierce the corporate veil in this case? Now, you have plenty of summaries. I gave you some. She got a book. Why did they pierce the corporate veil? In Adams versus Cape, why did they pierce it?
Did not accept that the use of the corporate structure to ensure that the legal liability in respect of the particular future activities of the group will fall on another member of the group.
Okay.
It's so difficult to use.
If
Justifies
you-
the veil being enhanced.
Okay. Even if you look at this one here on page 10, the last one that I gave you, page 10, it speaks to Adams versus Cape Industries. It says the courts are now increasingly reluctant to lift the veil in the absence of a sham. In particular, it is clear that the veil will not be lifted simply because it would be in the interest of justice. In Adams versus Cape Industries, the Court of Appeal was unequivocal on this point. Save in cases which turn on the wording of particular statutes or contracts, the court is not free to disregard the principle of Solomon versus Solomon, merely because it considers that justice so requires. Our law, for better or worse, recognizes the creation of subsidiary companies, which, though in one sense the creatures of their parent companies, will nevertheless, under the general law, fall to be treated as separate entities with all rights and liabilities which would normally attach to separate legal entities. So here she's put allowable if the courts consider that the group is what we call a single economic unit. So the court will say that the subsidiary and the parent act as one. And the case for that was DHN Food Distributors versus London Borough Tower. Who read that one? Yes, who was being diligent? You read that one? The summary is good enough. DHN. You remember that one? Okay, she has it here. What did it say? Read it out.
Okay. It said DHN was the holding company of a group of 3 companies where 2 subsidiaries wholly owned by DHN. One subsidiary owned land used by DHN and the other owned vehicles used by DHN. The land was subject to compulsory purchase and DHN sought compensation for disturbance of its business. In the Court of Appeal, the subsidiaries are bound hand and foot to the parent company and must do just what the parent company says. The group is virtually the same as a partnership in which 3 companies are partners. They should not be treated separately so as to be defeated on a technical point. It was therefore held that DHN was entitled to claim. The separate corporate personality doctrine was overridden. However, this is likely to only be followed where the subsidiaries are wholly owned and serve no purpose other than to own the parent company's assets. This case has not been applied to make one company in a group liable for the debts of another.
Okay, so in your handout, the same one we were reading from earlier, turn to page 14. And it says an influential case in this area was DHN Food Distributors and Tower Hamlets, which you just read. They say the Court of Appeal stressed the significance of the existence of a single economic unit and recognized the group as a single entity, allowing it to recover compensation. But the exact reasons behind the decisions are unclear. Then they say, go down to paragraph 50. They say to further confuse the position in DHN was a Scottish appeal of Wilson and Strathclyde Regional Council, that's in your notes, and also runs counter to many decisions of the courts in Australia and New Zealand. They say in Industrial Equity versus Blackburn, the High Court of Australia said that the group accounts legislation did not operate to deny the separate legal personality of the company. So she has here the company legislation required group accounts and to that extent recognize a group entity. Okay, so where did you find that in the company legislation? Is it in the book? Do we recognize group entities here in the Bahamas? Do you have it here? The company legislation required group accounts and to that extent recognize a group entity. So in this instance,
It was from
in
that
this
case,
instance,
for that case.
right, in this case.
I think that was why they considered it to be a single economic entity.
Mhm.
It was because the legislation
Required
required
it.
that. But otherwise, normally they would sit as
Separate
individual
legal entities.
legal entities.
Mhm. And an example where the company is a mere facade is Wolfson versus Strathclyde. Anybody read that one? Because I think I mentioned it in the notes. I told you attending homework, you know. Didn't bring that one? Anyone did that one? You have it in your book? So they don't have it.
Mr. Wolfson ran a shop in Glasgow specializing in wedding garments. In 1966, the shop premises were compulsory purchase for road development. Part of the shop premises, numbers 57 and 59/61 St. George's Road, were owned by Wolfson. The remainder, numbers 53/55, were owned by Sofred Holdings Limited, whose shares were owned by Mr. and Mrs. Wolfson. Wolfson and Sofred apparently received compensation for the value of the land. However, the claim for compensation for disturbance of the business, loss of profits, etc. was refused. This was because the business was operated by M&L Campbell Glasgow Limited. Campbell, a company again owned by Mr. and Mrs. Wolfson. Though Campbell occupied the premises, it had no interest in the land. For a successful claim for disturbance, the regulations required that occupation and a legal interest in the land coincide. So Wolfson, as appellate, pursued a series of arguments to establish this coincidence of occupation and ownership, finally failing to persuade the House of Lords that he and his two companies were in reality a single entity, both owning and occupying the land.
There you go.
The successful claim for disturbance or regulation required the occupation and legal interest in the land coincide.
And then they will pass a corporate veil where the subsidiary is an agent of the parent. Which case was that?
Stone.
Yes. Say it so they can hear you. Smith and Stone.
Stone.
Smith, Stone and Knight versus Birmingham Corporation. Y'all found that one? You did? Okay, read it out. Smith, Stone versus Birmingham. Birmingham. Oh. Okay, read the facts of that one.
That on here?
I thought you said you had it. Yeah.
Passing the covered field to obtain an advantage. A local government DC wanted to compulsory acquire land owned by SSK. The land was occupied by Birmingham-based company that operated a business there. BWC was a subsidiary of SSK. When the court recognized an agency relationship, it is a subsidiary company. If a subsidiary company is acting as an agent for its holding company, it may be bound by the same liabilities and rights of its holding company. However, no court has yet found subsidiary companies liable for their holding company's debts. SSK owned some land on a subsidiary company operated on this land. BK issued a compulsory purchase order on this land. Any company which owned the land would be paid for it and would reasonably compensate any owner for the business they ran on the land. Since the subsidiary company did not own the land, BK claimed they were entitled to no compensation. The court said that the subsidiary company was an agent of BC and BC must pay compensation.
So I'm making copies for those who don't have it. So they will lift it when it's group is a single economic entity, a mere facade or sham, where the subsidiary is an agent of the parent. Then they will also do it when there's abuse of corporate form. Anybody read a case for that? Abuse of corporate form. What's the fact?
Will it be back?
What's the fact in Guildford? page 6 on Radcliffe. At the top, it speaks to Guilford Motor and Horn, in which the defendant had been managing director of the claimant company and had entered into a covenant not to solicit customers from his employers when he ceased to be employed by them. And then on leaving, he formed a company to carry on a competing business, the shares in which were held by his wife and a friend, and he thereby solicited the clients from his former employer. The Court of Appeal held that this company was a mere facade or sham to cloak his breach, and was granted an injunction to enforce the covenant against him and the company. Good?
Which point is that case study before?
Abuse of corporate form.
Is that this, excuse me,
Mm-hmm.
is that the same thing as evasion of limitations imposed on conduct by law, or that's something completely different?
Mm-mm, that isn't the same thing.
Okay. And with the notes that you're referring to, I can have copies of that,
He
please?
didn't scan it to you?
No. Or, he scanned them this morning?
Should have been a few minutes ago.
Okay, I can check.
I'll make sure he sends it to you.
Okay.
Okay. And then when there's an agency, you have that case?
This was a civil claim by which the plaintiff sought to recover $1.3 million from Dollar Land Holdings, PLC, DLH. The complex facts can be simplified for present purposes as follows. Mr. Friedman, a Swiss national, had received the plaintiff's money on behalf of DLH, knowing it to be the proceeds of fraud. Though he was DLH's chairman, he had no specific authority to act on the company's behalf. The question for the court was whether the knowledge of Friedman, a director of DLH, that the money received was fraudulently disposed of in breach of trust could be imputed to DLH. If so, the plaintiff would have a possible claim against DLH to assets knowingly received by it and so held on a constructive trust. The Court of Appeal concluded that Friedman's knowledge could not be imputed to DLH on the ground that he acted as the company's agent in the transactions. However, he was to be treated for that purpose as its directing mind and will. Thus, Friedman's knowledge that the money was the proceeds of fraud could be attributed to DLH, and so the claim to enforce a constructive trust on grounds of knowing receipt could succeed. Bearing in mind how difficult it is in cases of transitional fraud to bring criminal sanctions to bear, the court was clearly anxious to see the civil action for the recovery of the proceeds succeed. The result is a very wide interpretation of the directing mind and will theory, perhaps taking it too far from its original narrow constitutional origins to a position more akin to the rules of agency. The case is also interesting for Hoffman L.J.'s discussion of the importation of organic theory into our law from Germany, on which the directing mind approach appears based. It is also interesting as a civil case on general principles in which judges, though possibly wishing to achieve their own policy objective of restoring stolen property to its rightful owner, could not fall back on the presumed intentions of Parliament through interpretation of a criminal statute.
Okay, so that's LRU. Tariki, you asked a question about abuse of corporate form and whether that was the same as evasion.
Yes, ma'am.
Okay, so yes it was, and then you used the case along with that with Jones and Lichtman.
Yes. Okay.
Persons also seek to pierce the corporate veil in matrimonial matters. Okay, scan it Dorico,
Yes, ma'am?
he said your email bounced back.
Okay, tell him, ask him if he can send it to my private, email rather than the company, please. wellsdorica@gmail. I don't know why it's bouncing back.
So I was saying, persons try to pierce the corporate veil in matrimonial matters. And the case that's being discussed in a lot of articles is Pressed versus Petrodel Resources. (2013) UKSC 34. So in this case, the divorcing couple, Mr. and Mrs. Press, were wealthy. They own a substantial matrimonial home in the UK and a second home in Nevis. Mrs. Pratt contended that her husband's wealth vastly exceeded this and argued that properties held by several companies, of which Mr. Press wholly owned and controlled, were in reality owned by him. The case was originally heard in the family court as an application for an ancillary relief by the wife in a case of divorcing spouses, where it was held that although there was no general principle by which the corporate veil could be pierced, this was possible under the Matrimonial Act. 3 of the companies of which Mr. Press was the majority shareholder appealed to the Court of Appeal, in which the majority criticized that the general practice of the family courts to use the Matrimonial Causes Act to pierce the corporate veil, and asserted that in the absence of abuse of the Solomon Principle, the law did not permit this. So this was the wife seeking to pierce the corporate veil, to go behind 3 companies that her husband owned in order to get more of his assets. And the court said no. Because to pierce the corporate veil, it has to be on one of these grounds. And they said there's a better way for her in order to get access to his assets, and which was she would go under the rules of equity and show how she would have contributed towards him acquiring this wealth, but not by piercing the veil. So we got on that? So you know this is an examinable question, without a doubt.
I don't understand these answers because you say there have been instances where the court has lifted the corporate veil.
Yes,
Let's discuss these instances. So I would not, if she wasn't successful,
No, she wasn't successful.
I would not have used that.
No. But at the very beginning, before you start, you have to say, what are the instances when the court will lift it?
Oh, okay.
So you lay them out.
Okay.
And then you pick from there where they have actually done it.
Oh.
You use the cases where they have lifted it.
Mhm.
You see? So when you start, you would say that the court will lift the corporate veil in these instances.
Yes, but you said you used this case where she was not successful.
No, I just said at the end that there have been instances where people seek to use it in matrimonial matters.
Oh, okay.
Yeah, as at the end.
And then you would use this case to show that they were not
Yeah.
successful. Oh, okay.
Yeah.
Okay.
But you had indicated if they had found fraud, then they could
Yes,
have
then it would have,
lifted it, right?
yes, but was no fraud. Don't forget that had to be under one of these grounds. And they weren't able to prove it.
So the grounds are, abusive corporate form,
Mm-hmm,
agency,
mm-hmm,
illegality,
mm-hmm. Mere facade,
and
a sham.
So what is the statute? What is that?
Statute, that's if, say the government passed an act,
Mm-hmm.
and in the act they state, these are the conditions upon which they will lift the corporate
Veil.
veil. Okay. So it's mandated by law.
That's how our answers should be outlined, similar to what you did. Okay,
If it was right, then I would have taken it off the board.
okay.
Yeah.
I just want to have an idea.
I mean, the way she wrote it is a good way to study it.
Yeah, I realize that.
But
yeah.
you'll have to take that question now and write it out
Oh.
as an
after-
essay form. Yeah.
Okay, okay.
That's her sketch of
That's how
how
she
she
broke
would
it down, yeah.
break it down.
Okay.
Okay? So someone else needs to try this one.
And then I get to letter each of them to get it with the six. I try and follow me with the six. The first letter of the sixth word. And you review from the noise.
That's the easy one. You try that one, Ingrid? Why are you always turning pages?
Cause I looking at my notes.
So I can just,
Be quiet.
can I just say
Ingrid.
it from here? Just, you know, I have it.
Okay, tell me.
The advantages, they make all the decisions, the sole proprietor make all the decisions, receive all the profits, and minimal filings, that is business license, fees, business license, VAT, and NIB. That's all I have.
Pick up some more. Pick up some more. Remember the notes are just to get you started?
No interference, no.
Yes, no interference, okay. Any other advantages of a sole proprietorship?
No, because not everything else come under decisions.
No filings.
Minimum
That's minimum filing.
documents.
Just that, yeah. Anything else? For sole proprietorship?
That I can think of.
Yes?
Maybe depends on what they sign up.
It's still low, because if it's more, then you would need to go, you need partners. Normally, a sole proprietorship, the startup cost is very low. Anything else?
You don't have to share the profits?
They receive all profit.
Receive all profits, number 2.
Okay, yeah.
Yes? Okay.
What do you mean by that? Oh,
Oh,
open
yeah.
account, we
Open
got
account,
something
yeah.
else,
Then
sorry.
it could be a.
Yeah, but that's-
Sylvia.
So what do you
Yeah.
mean, by that, open account in
It's not in the company, it's in his name.
oh, okay.
That's an
because-
advantage to him.
Okay, I understand.
Any other advantages for sole proprietorship?